If you've ever done an eviction and you looked at the answer filed in your eviction, you'll see those answers are, 9, 10 pages with literally hundreds of check boxes. So if they're if they're checking all of the boxes and you're going to end up doing some discovery, that's going to delay the process. But also a big factor is the landlords who we've created a checklist now because we're starting to see this happen more and more. So now we've got a checklist where the landlords have to fill this checklist out. Okay, does your property fall under a just cause ordinance? Yes. Okay. Does that just cause ordinance require you to register the property? Yes. Is that property registered? Yes. So they go through and they check these boxes, and then they find out later, well, I sent my check in. I thought it was registered. Well, did you ever get a copy of the registration in the mail? No, I never got it in the mail. Well, then your property's not registered and your whole case has been a waste of time. Now you've got to start over.
Hi, this is Chris German from The Apartment Dealer. Welcome back to The Apartment Dealer Show. Today we'll have with us Mr. Mike Brennan. Now, Mike has specialized in tenant evictions for the last 18 years, serving landlords here in Southern California. There's hours of interviews already that are on our website with Mike speaking to other topics. Today, though, we're going to talk about what's new for 2025. Over the course of the last 12 months, those laws that were being contemplated, which ones actually became law, and then what's on the horizon as we continue out throughout this new year, and how does a landlord deal with all the oversight, the legalities of owning multifamily properties? What are the tricks and traps that landlords are falling to? What's most common that's hurting the landlords legally? We're going to dig into all that and more. So here we go. So Mike, welcome back to the show.
Hi, Chris. Thank you.
Now, of course, we have by now hours of content that we've recorded together that lives here on my YouTube channel. We're recording this in 2025, beginning of the year, so we wanted to bring people up to speed, what's taken place essentially over the last 12, 24 months here. And then looking forward, what should we be cognizant of as we're recording this? Even in LA right now, they're contemplating a new rent freeze and that sort of thing. So things are always evolving. So word to the wise here, what Mike's going to share is essentially effective as of today, could even change tomorrow. That's always why you want to have good counsel by your side. But Mike, again, thank you for being with us. Let's dive into new landlord-tenant laws. Since January of 2024, what are the most significant changes in landlord-tenant laws that multifamily property owners in LA, San Bernardino County need to be aware of?
Well, there were quite a few new laws. I'm going to give you the top, let's call it the top 10 that I think everybody's got to be aware of. AB 2493 would be the first one. That's a change in screening fees, screening policies, and credit reports. So there are going to be prohibitions on screening fees. There's going to be mandatory screening policies. There's going to be two options that landlords will have to choose from. And then there's going to be mandatory credit reports, which means, if you run a credit report on an applicant, then you're going to have to provide them with a copy of that report. Now, going back to the mandatory screening policies, this one, everybody really needs to know on this one is for decades, there's been a myth that you had to mark your applications with the first number, you number them as they came in. First person is number one and so forth. And then you had to pick the first qualified, and that's always been untrue. This new law, AB 2493, kind of changes that. If you want to collect screening fees, you're going to have to pick from two options. Either you can charge the application fee when the applicants are provided with a written copy of your rental criteria with the application, so that you do it at the same time. And then the landlord would have to process applications on that first come, first qualified, first accepted basis. That's if you want to take the screening fees. Option number two would be you're not required to accept the first qualified applicant, provided you return the fee to any applicant who's not selected within 7 or the lesser of 7 or 30 days. So in other words, let's say you choose somebody else, within 7 days, you'd have to return those screening fees. Or let's say 30 days comes around and you haven't chosen anybody, you'd have to return the fees to anybody that had paid them at that point.
So let me ask you this, because I just went through this. I just rented one of my vacant units. So let's say you receive 7 applications for a particular apartment vacancy, and you lay those 7 applications out. Let's say everybody meets your credit requirement. Let's say you're saying 680 or better, let's just say, and you're asking for at least 1 year on the job. Okay, check, everybody has got that. But one applicant, let's say, just makes more money, right? So you feel more secure about their financial wherewithal. Sure. They might not have been the first person that applied. They might have been the last person that applied. But you know what? They work for Tesla. They don't work for, someone else making less money. Can you choose that person simply based upon the fact that they have more income? Will that be seen as you're being discriminatory?
No, it will not. It's based on their income. And that's what I was saying. That's always been the law. You were always able to choose the best qualified over the first qualified. This new law is changing that. It's saying if you want to accept or if you want to collect screening fees, then you're going to have to pick one of these options. You can charge the application fee when you give them the rental criteria with the application, which I think everybody should be doing anyway. Have your written rental criteria written out and give it with the application. And then if you process on a first come, first qualified basis, then you can take those screening fees. The other option is you are allowed to accept that first, the best qualified applicant, provided you're willing to return those screening fees to anybody you didn't take. So I think for me, it's a no-brainer.
Yeah, it's a no-brainer. Just don't charge screening fees. It's very simple.
Or the alternative, Chris, is send your applicants to a third party where you're not collecting the fees. So maybe they have to pay that third party, and that third party forwards their credit report to you. And then they didn't pay you, you're not collecting the screening fees. And so that's an alternative. The law didn't address that. And then again, I just want to remind everybody, like I said, in the end, every applicant gets to get a copy of their credit report, rather than just the people that you denied or required a higher deposit or a cosigner. That was the old law.
And so I'm going to give a shout out here. There's a website, Rent Spree, SPREE. That's what I use for my own vacancies. And it's just that. They receive a text message or an email from this company. They pay that company directly. It's about $40. And then you as the landlord receive a copy of the credit, the eviction history, criminal history, and the tenant also receives that same report, the same thing you're receiving. I'm not charging anything above and beyond. I don't need to make a few bucks on screening fees. To me, that seems like a ridiculous idea. Again, not judging. But again, it's a neutral third party that's sending the reports, and it's very user-friendly. Maybe they'll pay me a couple bucks for sharing their name, but no affiliation. But that's who I use. It does exactly that. It's a third party. Yeah.
So like I said, at the last iteration of the law that I read, didn't address that at all. So that's a very viable option. So that was 2493. Let's go on to AB 2801. Now this is the security deposit accounting changes, and this every landlord is going to have to know. This law actually. So most of what this law does is the landlords, if they read it, would say, well, I'm doing that anyway. But the changes in here are subtle but significant. So what this law does now is it limits the permissible claims against the tenants, meaning like a small claims action, or their security deposit, to only those cleaning services and repairs that are reasonably necessary to restore the unit into the same condition it was in when you gave it to the tenant, exclusive of ordinary wear and tear. So what I'm saying is, ordinary wear and tear, still the same. You don't get to charge for that. And you used to be able to, use the deposit for cleaning fees or repairs beyond ordinary wear and tear. But now under this new law, you've got to be able to establish that it was reasonably necessary to make those repairs or clean it to put it back in the same condition it was in when you gave them to them. And that phrase reasonably necessary, those limitations apply to the materials or supplies and labor provided by either the landlord or the employee or a contractor or even a professional carpet cleaner. So this is going to get a little bit difficult, especially on the carpet, right? How do you prove that? So a lot of landlords, they just, as a blanket policy, they'll say, I clean the carpets after every tenancy. that's not going to be permitted anymore. You're going to have to prove that it was actually reasonably necessary to clean that carpet. So how do you do that? That's difficult. You're going to have to learn how to take really good pictures. And speaking of that, that's also a new requirement under this law. So I've been telling people for 18 years I've been practicing now, always take pictures at the inception of the tenancy, but before you hand it over to them, so you can establish the condition of the property. Well, this law actually now requires pictures to be taken at 3 different times. And there's 2 different trigger dates for this. I would say ignore the trigger dates, just start doing this immediately. So you're going to have to take pictures, and I suggest they be color. And if you can, just go to Costco or Sam's Club or something and buy one of those $20 Sanyo or Sony cameras that can put the date and time stamp on the picture. So take the pictures in color of the entire unit, from everything, from the door, the carpets, the baseboards, the walls, the outlets to prove that there were covers on them, the light switches, the ceilings to prove there's no water damage, every aspect of that property, all the screens, everything. And then take those to your walkthrough. This is not the law. This is just my suggestion. Take those through to the walkthrough and have your tenant sign off on the back of them. All right, so that's your first set. You've got to take those at the inception of the tenancy. The second set that is now required is you have to take pictures after the tenant vacates, but before you do any of the work. And then the third set that's required by law now is you have to take a final set of pictures after the work has been done. And you can see where they're going with this. And as a landlord myself, I've done this many times in the past. When I did the accounting, I would send them a stack of pictures, 3 inches thick. Hey, here was when you took the property. Here's all the repairs. Here's the damage before I did it. And here's the repairs to it. Just so they could never come back and say, oh, that was there or something along those lines. But now this is all by law. You have to take these 3 sets of pictures. And then the last aspect of this law is you still have to do the accounting within the 21 days. And you've got to include those pictures in the accounting. And you can agree that this is a nice aspect of it. After the tenancy is terminated now, you can agree that the accounting can be provided to the tenant through email. So you just send the accounting plus the set of pictures. But the final subtle criteria to this is, as part of your security deposit accounting now, you are required to explain in writing why you needed to do each repair. Why was it reasonably necessary? So it's got to be in writing now, not just pictures, but also it's got to be written out. So if you say, I repaired the screen, you've got to say, because there was a 4-inch slice in the screen that was not there when you took possession of the property. The next one is, it's a combination of 2 laws. It's AB 2747 and SB 924. And this is a law that now requires, it's called mandatory offer of positive credit reporting. So you remember, Chris, last year, we talked about the fact that Section 8 tenants, landlords had to offer them the ability to improve their credit by the landlord agreeing to pay to each month the tenant paid on time. The landlord had to report that to one of the 3 major credit reporting agencies. That law has now expanded now to that most landlords, it requires landlords of all residential properties to extend that offer to at least report to at least one nationwide credit reporting agency. And again, there's some trigger dates on that. These are important, so I'll go through them. Any lease that was in existence as of January 1st, 2025, you've got to start doing this by April 1st. So that's just 2 months away. Any lease entered into after April 1st, you've got to do that at the inception of the lease. And in both cases, you have to do it annually thereafter. So every year now, landlord's going to have to reiterate that offer that, hey, you have the right to have me report your positive credit. You can make that offer through mail, but if you do that, you've got to provide a self-addressed stamped envelope for them to mail it back to you. And you are allowed to recover some costs, but it's important to understand the limitations on that. So you can recover the lesser of your actual cost to do it, or $10 a month if the tenant opts in. Now, if the tenant fails to pay on time, then the question is, are you allowed to negatively report that credit? So if you do that, and I would suggest that the whole industry, now that this is law, I would suggest the whole industry start moving in that direction. Have the tenants say that if I'm going to opt in, I'm going to allow both positive and negative credit reporting, because this is a great law to circumvent the fact that evictions are sealed, right? You file an eviction, it's sealed. You're never going to know about it in most cases because the vast majority of cases never actually go to trial. They settle, and that record remains sealed. With this new law, if you're reporting, even if you don't report the negative, if you're reporting the positive all the time, and then all of a sudden you've got an applicant and there's 3 months, the last 3 months, there's no positive credit reporting, a red flag is going to go up right away, and you're going to suspect that, hey, this tenant is probably being evicted right now. And it'll cause you to dig deeper into their current tenancy. But let's talk real quick about what you can and can't do on these fees. What do you do if the tenant doesn't pay the fee? Well, there's not much you can do. You can give them a warning letter, and then if they don't pay within the 30 days, then you can stop the positive credit reporting, and they're not allowed to ask you to opt back in for at least 6 months. What you cannot do is you cannot take it out of their rent, and you cannot take it out of their security deposit, and you cannot evict them for it. So just remember the limitations on that.
What about existing tenants who lived in the units prior to January 1st, 2025? Do you have to give them all the option?
You have to give them all the options as of this April 1st or by this April 1st.
Got it.
There's an exemption in here that if you read the language of the law, it's incredibly confusing. So I'm going to try to explain this in as plain English as I can. So those landlords who own a property with 14 or less units are exempt unless the following two factors both apply. So the first factor is the landlord owns those in more than one building. So let's say they have, two 7-unit buildings, two 7-unit buildings. That's still 14 or less. So that landlord is still exempt right now. And the landlord is either a REIT, a corporation, or an LLC with a corporate member. So that kind of reminiscent of the Tenant Protection Act. So let me walk through that again. A landlord who owns 14 or less units is exempt unless both of these apply. They own those 14 units in multiple buildings, and they are either a REIT, a corporation, or an LLC with a corporation as a member. In that case where both of those apply, that landlord is not exempt, even though they own 14 or less units. All right. So last thing I'll touch on this is be careful, when your tenant's not paying rent. If they're not paying rent because it's a repair and deduct situation, let's say their hot water heater blew and you couldn't get it fixed in a couple of days, and they said, oh, forget it, then I'm going to go repair it and deduct that from my rent. You would not be able to not report that as a positive credit reporting, but they've got to notify you guys in writing before the rent became due that that's what they were doing. So there's some limitations on it. Again, for time purposes here, I would just suggest that your members or your viewers pull these two laws, read them in conjunction. It's AB 2747 and SB 924.
Got it.
The next law that's important to understand is SB 1051. This is a domestic violence law. And basically what it says is if the tenant reports to you that they need their locks changed, you have to change them within 24 hours and you have to pay for it. And if you don't do it within 24 hours, the tenant has the right to change them on their own. They've got to use the same or better quality locks, and they've got to provide you with a copy of the key. But you still have to pay for it. So there are some requirements under this one. An eligible tenant, for example, that's the phrase used in the law, has to be either a tenant, their immediate family member, or a household member who is a victim of abuse or violence. And the tenant's got to put their request in writing that you change it. Plus, they've got to provide some documentation to prove that they are the victim that they're claiming to be. For example, they've got to provide you with some sort of a temporary restraining order, a protective order. A third-party documentation will also work. So, for example, if they are seeing a therapist and the therapist says, yes, they are, a victim of violence or something along that lines, as long as it's credible, then, that would suffice as far as the written documentation is required. And like I said, if you don't change it within the 24 hours, they get to do it. They just have to notify you that they did it, give you a copy of the key, and then you have to pay for it.
Got it.
All right. The next one is 2347. This is the one that I think the industry will get the most upset at first until I walk through it. But this is the one where anybody who's doing an eviction knows that if you serve the tenant with a copy of that eviction personally, that tenant has 5 days to respond. That doesn't include weekends or holidays. So in most cases, that's going to be really 7 days to respond. This law has now changed that. As of January 1st, they now have 10 days to respond. Now, if you look at a calendar, that's really going to work out to about 14 to 15 days, depending on when they get served. The reason I say this is not that big of a deal is because most households have more than one tenant named. And it's often the case that one tenant will be served personally, but the other tenant gets what we call subserved. They're served through the tenant that got served personally. And that gives that tenant extra time. They didn't change the response times for that other tenant who gets subserved. So basically, all they're doing is taking the tenant that got personally served and putting them on the same track, the timing track, as the person who got subserved. So in the end, it's not going to work out to be anything terrible unless it's a single tenant. You just doubled, maybe even tripled the time they have the answer. But the flip side to this law is the legislature actually did something good for landlords. Oftentimes, the tenants will file a motion called a demurrer. And the only purpose of that demurrer is to delay the case. And they'll set that demurrer out, let's say 30 days. And what this law does now, I should say, if they file a demurrer, they do not have to file an answer to the complaint until after that demurrer is heard. What this law does is it streamlines that, and it says we're not going to set these out 30 days anymore. These demurrers and motions to strike have to be filed and heard. I'm sorry, they have to be heard after they're filed within 5 to 7 days rather than 30. And instead of the landlord having to file a formal written opposition to those motions, they can actually argue it orally on the day of the hearing. So that really cut down some time and expenses for landlord, because it was expensive for the landlords to have me draft that opposition, then show up for the hearing. And what I anticipate, because I've seen courts do this now, what I anticipate happening now is the judge, if the tenant files a demurrer, it's very, depending on the courthouse and the judge, it's very likely the judge will actually rule on that before it ever even gets to a hearing date. He'll say, we ruled from chambers and it's overruled. 99% of them are overruled anyway. So like I said, the legislature actually helped the landlords out on that aspect.
Got it.
All right, the next one is SB 611. This one is just a prohibition on specific fees. Landlords are not allowed to charge tenants fees anymore if the landlord serves some sort of a termination notice. A lot of my clients did that. We put it in their lease. If they had to serve a notice, they charged them somewhere in the neighborhood of $275 to $300. Can't do that anymore. And you're not allowed to charge the tenant a fee for paying their rent or their security deposit by check anymore. I will add that this law actually applies to qualified commercial tenancies as well. So if any of your members own commercial properties, be careful, even if the lease says you can charge that. If you have a qualified commercial tenant, you can't charge that anymore. The next one is, let's see, let me make sure I'm not skipping anything here. AB 2533. Let me jump to that real quick so I can take a look at my notes. This is a streamlined ADU process. This is great. What the city, everybody knows we have a housing crisis. What the cities are trying to do is, the city knows there's a lot of illegal bootlegged units out there and illegal ADUs and pool rooms that are rec rooms that were completely permitted, but they never got the C of O. And the city wants to bring the state wants to bring all of those online. And so what they've done is they've created this streamlined process, and basically it's expanding a current program which allows specific unpermitted ADUs to become permitted, including junior ADUs. That any of these units that were built prior to 2020, they can become permitted. And the way they do that is it's going to require local agencies through the city to provide the public with various forms of information. So they're going to have to provide information about the process of permitting it, what checklists can be used. It's going to have to advise the owner of their right to have a confidential inspection of the unit, which won't be used against them. And it's going to limit any fees or penalties to the landlords who are trying to bring those units online. So again, for anybody watching this down the line, if you've got these unpermitted units built prior to 2020, now's your opportunity to get them online. Let me just real quickly tell you where this comes to bite people if they don't do this. You can have somebody that's been living, and these are real life scenarios that I've faced with many of my clients. You've got this bootleg unit, even if you didn't know when you bought the building, maybe the setup sheet didn't tell you it was bootleg. But you've got somebody who's been living there. You've owned the building 10 years. Now you know it's bootlegged. They stop paying their rent. You go to evict them. And not only do they defend the eviction because there's no certificate of occupancy, so they didn't have to pay you rent, but they're going to talk to some attorney who's going to say, hey, by the way, you should sue your landlord for all that rent you've ever paid because you didn't have to pay it. And so again, if you've got one of these illegal units, this law in particular is your opportunity to get out from under that. And if you do get out from under that, and you're looking for some sort of a waiver or something, go talk to an attorney who can do that. We can certainly handle that. But other firms as well can handle that. They can get you into a written agreement with your tenant where they waive that ability to sue you for that later.
So should the landlord read this as any illegal unit that they may have? They turned a laundry room into a unit, a garage into a unit, that now it's like a blatant, yes, this is now going to be approved?
I would not go that far. That's a great question because that's not really what I was envisioning. I was envisioning, like I said, the bootlegged unit, not a laundry room. We're talking about units that are, well, I guess the inspector would come out and tell you, what do you need to do to get this fully permitted and get your certificate of occupancy issued on this? So a broom closet is probably going to require quite a bit of work, right? A laundry room also probably going to require quite a bit of work. But what do you do with the individual who's watching this and they've got out by their pool, they've got a really nice rec room that has plumbing, it's got all the electricity, it doesn't have a C of O, but it's got all the necessary permits when it was built. It wasn't really meant to be a residential unit. It was meant to be a rec room, but it's got everything. That's the kind of situation where that one's going to get through pretty easily. So I wouldn't want to sit here and speculate what will go through and what won't go through. But it is a law.
Just ask, because I could, for many of them, they have to ask themselves, well, do you want to open the can of worms? And obviously
right, yeah. But remember, like I said, it provides for a confidential inspection. But again, like you said, yes, it's a confidential inspection, but now you're on the radar. So, how far does a confidential inspection go? Who knows? All right. The next one is SB 1465, substandard buildings. This one's important because what it does is the state is mandating new inspection requirements by cities. And it's expanding and clarifying definition of substandard buildings. I won't go into all the details, but what I will say is this law authorizes any enforcement agent, a tenant, or a tenants association to seek an appointment of a receiver if the property receives a violation and it hasn't been cured. So that is huge. And in fact, to me, that's scary. So you've got these violations, you got cited on a violation, maybe you're struggling to get it cured, maybe you've got an inspector that just doesn't like you and is making your life very difficult, and every time they come out, they find more violations. A tenant, an enforcement agency, or a tenants union, like a tenants association, can actually go to court now and petition to have your building put into receivership. That's crazy. So again, I would encourage everybody to look up SB 1465 and understand what's going on. And if you've got any issues on your property, even if there are issues that come and go, make sure you're taking care of them right away. All right. And then last but not least is AB 2622. And this one's actually a plus for landlords as well. This one basically just said previously, if you had work that had to be done and it was going to cost $500 or more, you were required to use a licensed contractor. They've now bumped that amount up to $1,000. Yeah. So that works out. So again, those are, I'd call that the top 10 or so laws for that are going into effect for 2025.
So the eviction process, so that's next top of mind. So let's address, say, how has that evolved over the last 12 months? And is there anything slated to change this year with respect to the eviction process?